Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy! The Queen and Hannora, heard on June 1st, 2020, in writing, on appeal from the sentence imposed on September 14th, 2018, by Justice Guy P. DiTomoso of the Superior Court of Justice. Mr. Hannora appeals the sentence imposed on him arising from his conviction on 3 counts after a trial with the jury. Mr. Hannora was sentenced to 3 years on account of unauthorized possession of a restricted firearm, 1 year consecutive on account of possession of a firearm while prohibited, and 3 years consecutive on account of received material benefit from sexual services, for a total sentence of 7 years. Mr. Hannora abandoned his conviction appeal. The background of facts can be stated briefly. The complainant was a sex trade worker who entered into a relationship with the appellant. The complainant continued to work in the sex trade while she was in this relationship with the appellant. The appellant received monies from the complainant, which he used for his own personal expenses. The complainant also moved into the condominium that the appellant owned and paid rent to the appellant. On occasion during the relationship, the appellant was abusive towards the complainant. There were acts of physical violence. On one occasion, during an argument, the appellant produced a loaded handgun and threatened the complainant with it. It appears that the appellant had the handgun with him on other occasions, including when he went out in public. The complainant handled the handgun and at one point asked if she could shoot it. The relationship ended after a few months. The appellant was 27 years old at the time of sentencing. He has a criminal record that includes convictions for theft under, mischief, break and enter, possession of a weapon, and a number of breaches of court orders. It is of some importance that the longest sentence that the appellant has received prior to these convictions was for a total of 330 days, or slightly less than a year. There was a pre-sentence report before the sentencing judge that spoke positively about the appellant. As the sentencing judge observed, the appellant had accepted responsibility for his actions and enjoyed strong family support. The sentencing judge also said, quote, "Mr. Hannora has been described as a mature young man who had been making efforts to better himself and who now needs to continue to learn from his mistakes," end quote. In our view, the sentencing judge erred in his approach to the sentences he imposed by failing to properly apply the totality principle. The only mention of the totality principle made by the sentencing judge was with respect to the 3-year sentence he imposed on the firearms conviction, when he reduced what he considered to be an otherwise fit sentence on that count from 4 to 3 years. The totality principle is properly applied to the total sentence imposed on an offender. Its purpose, where consecutive sentences are imposed, is to ensure that the total sentence is proportionate to the culpability of the offender. As Chief Justice Lemaire said in the Queen and MCA, quote, "The totality principle, in short, requires a sentencing judge who orders an offender to serve consecutive sentences for multiple offenses to ensure the cumulative sentence rendered does not exceed the overall culpability of the offender." Having determined the fit disposition for each count, and running the sentences consecutive to one another, the trial judge was required to look at the total sentence of 7 years and ask whether it exceeded the overall culpability of the appellant. The failure to do so reflects an error in principle, one that impacted the sentence imposed. Accordingly, it falls to this court to do so. In the circumstances of this case, having regard to the circumstances of the offending conduct, a total 7-year sentence for a 27-year-old offender who the trial judge accepted had positive prospects for rehabilitation, was generally remorseful, and whose previous longest sentence was less than a year, outstripped his overall culpability. On the rehabilitation aspect, we repeat the observation of Appeal Justice Watt in The Queen and Angelus, where he said at paragraph 51, quote, "Totality is a principle of sentence for the purpose of which is to ensure that the total sentence imposed does not extinguish the rehabilitative potential of the offender," end quote. While we do not diminish the seriousness of the appellant's conduct, the total sentence was excessive given the mitigating factors that we have mentioned. The principle of totality should be applied to reduce the overall length of time the appellant must serve in custody. It is recognized that one way to reconcile the overall sentence with the totality principle is to impose concurrent sentences, where otherwise the sentences would be consecutive. This approach has been favored by this court in a variety of decisions, including the Queen and Jewell, where Appeal Justice Finlayson said, quote, "In performing this function, the trial judge will have to consider not only the appropriate sentence for each offense, but whether in light of totality concerns, a particular sentence should be consecutive or concurrent to the other sentences imposed," end quote. Taking into account the mitigating factors that we have mentioned above, the appropriate total sentence in this case would have been 4 years. The result can be accomplished by making the sentence on the received material benefit count concurrent to the other 2 counts. We would grant leave to appeal sentence, allow the appeal, and make the sentence on count 3 concurrent to the sentence on counts 1 and 2. We would also set aside the victim fine surcharge.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.